from the daily list. Item number 1.
Please, Your Lordship. Lordship, this is a public interest litigation in relation to a building, my lord, a school building, which is the St. Anthony's Lower Primary School.
Please speak a little louder.
Yes, my lord. This is a school building, my lord, which is a 123-year-old building. And it's situated in the Don Bosco Square, my lord, the heart of the city, my lord, which is about 1 kilometer away from here, and holds a very significant historical position, my lord. And recently it has come out in the news that the school authorities, basically, this is managed by the Salesians of Don Bosco Educational Society, my lord. So recently it has come up on the news, in the newspaper, my lord, that they are planning to dismantle the building, my lord, during these vacations after the school exams, which have already complete, and they are in the process of preparation, my lord. My lord, this building, my lord, holds a very significant, my lord, it's a Assam type colonial structure, my lord, built in 1902, my lord. Thereafter, in 1922, it was taken over by the Salesians of Don Bosco, my lord, and since then the school has been running. If your lordships kindly have the picture, my lord, at page 12, annexure 1, my lord. Basically, my lord, the Don Bosco Square area is an educational hub, my lord, where most of the schools and colleges situate, my lord. If your lordships kindly have page 12. So, my lord, I have annexed a picture. This is the oldest picture that we have of 1974. And the bottom is the recent picture, my lord. So this statue, if your lordships can see, this is called the Don Bosco Square statue, my lord. So the school is behind, the old structure, colonial structure, my lord. It has a lot of historical significance, my lord. Page 13, your lordships will also see different angles of the structure, my lord.
Have you given notice to the school authorities?
No, my lord, I have made them a party, my lord. Basically, my lord, there's an act. There's an act, if your lordships...
Yes, I've seen it. The Meghalaya Heritage Act.
Yes, my lord, of 2012. So there's an authority, my lord, which is in place in the scheme of the act under section 6. Now, my lord, under section 3 of the act, my lord...
You see, there are two issues involved.
Yes, my lord.
It is not the only place where this issue arises.
Yes, my lord.
One is the question of ownership and management of the building.
Yes, my lord.
Ownership must be with the school.
Yes,
the right to sell it is with the school.
Yes, my lord.
Manage it with the school.
Yes, my lord.
Then there is the question of heritage.
Yes, my lord.
Once it is declared as heritage, the owner loses the right.
Yes, my lord.
To dispose of the property, or even to deal with the property, or even to repair, renovate, etc.
Correct, my lord.
So on one side, there are exponents of this right that declare it heritage, etc., which affects the rights of the owners.
Correct.
All right?
Yes.
So the school authorities are a necessary party here.
Yes, certainly, my lord.
And you give notice to the heritage, the
authority, my lord.
Yes.
I have made the authorities a party at respondent number 3, my lord, and the school 4 and 5, my lord.
Who is the petitioner?
But petitioner is a citizen, my lord. He's an artist, basically. Concerned citizen, my lord. By profession, he's an artist.
Have you served them?
My lord, I've served the state and the authority, my lord. Number 1, 2, and 3. 4 and 5, my lord, notice will have to go, my lord.
4 and 5. Who's appearing for 3?
Lordship, I'm appearing.
Mr. Khan.
I'm appearing for 1, 2, and 3, Lordship.
1, 2, and 3.
Lordship, yes. Because under the Act, Lordship, if your Lordship, I take your Lordship to page 29, clause 3, subclause 2.
So there must be a procedure for declaring
Lordship,
Section 3.
heritage buildings.
Lordship, I will just take your Lordship to section 3.
Section 3, ma'am.
Section 3, page 29.
So with regard to this school building, has any step been taken? Up to now, no.
No, Lordship, no. But then how things should happen and how the Act has to be set into motion. If your Lordship, can I take your Lordship to page 29? Lordship, clause 3, subclause 2. So, Lordship, the first requirement is that the authority has to be of the opinion. Now, if your Lordship, I take your Lordship to page 28, meaning of authority, 2 subclause B, page 28.
1 minute, Mr. Khan. Sorry. Yes. Then thereafter,
Lordship, we take to page 28. Clause 2, subclause B. Authority has been defined as to, it will be constituted as per section 6, and then Lordship will come to page 30. 6, the constituent of authority is elaborately stated in page 30, clause 6. Now, Your Lordship, for the present purpose, Your Lordship will come to the definition of heritage building. That is at page 28, clause 2, subclause I. Page 28.
अच्छा later देखो ना for us to entertain it, let them give a preliminary report. We hold a meeting. Instead of a written report, oral instruction. তাই জন্য বলছিলাম যে এটা পুরো কমিটি করার দরকার নেই কাউকে যে ইন্সপেক্ট করে যে প্রাইভেসি সাবস্টেন্স litigation here, that is litigation. You go to get oral instructions about you give notice to the school, Mr. Khan. You see Rule 8.
Rule 8, yes. Lordship, yes.
From the committee,
Lordship.
you nominate an officer to go and inspect the school and to give you instructions whether prima facie this thing can be gone into.
Lordship.
And then we will notice the school also hear that. And then if you think that prima facie, yes, that whether it is heritage or there is substance in the statements made in the petition, then we may ask you to exercise your power under Rule 3.
Absolutely, Lordship, absolutely correct. That would be the stage
But to
where,
entertain the writ,
Lordship.
prima facie satisfaction of the court also has to be made. So we will ask your officer to inspect and to give you instructions which you will communicate to the court.
Lordship.
ওদের এটা বলছি ফর দিস পারপাস যে পুরো কপি থেকে যখন কনভিন করছে মানে খুব ওই হবে মানে এত বুঝে অফিসার মানে সিনিয়র থেকে
It's a very detailed act, Your Lordship. There are a lot of aspects, every aspect has been covered. And for a moment also, Lordship will just come to 2D. What is the meaning of development? 2, section clause 2, D, page 28. Even with preserving the structure, still development can be made. So the detail elaborate. And what has fallen from your lordship is
It is there in Calcutta also.
Lordship,
All this act
yes.
is to prevent all historical, archaeological, or buildings of aesthetic value from falling into the clutches of developers, because the owners tend to dispose them of,
Absolutely.
and they fall into the hands of developers. And even otherwise, even if not developed, they are ill-maintained by the owners because of lack of economic resources.
Lordship, just day before yesterday, something very interesting happened in Mumbai. I just wanted to share. Lordship can go leisurely, but the century-old Charni Road School wins UNESCO Heritage Award. So there was a group of people who were advocating the cause of and the main thrust was the lordship trying to strike a balance between conservation and development. How do you conserve and how do you allow a part of the city which is heritage and development?
So not even our prayers for them to examine, my lord.
Lordship, the state rule will only come in, what has fallen from the lordship is very clear. State rules will come into motion only when there is a preliminary report.
Yes, yes.
As to whether we should set into motion
Yes,
section
you
3.2.
The satisfaction of the committee.
Absolutely. Set 3.2.
As we speak, my lord, this morning, they have already cordoned the school building by covering for starting the dismantling, my lord. That is the development this morning, my lord.
So why didn't you give notice to the school? One who's affected by an order should be noticed. Otherwise, it becomes an ex-party order. That you are asking for an order of injunction restraining them from proceeding with any.
If your lordships may issue notice, I can come back in 2 days, my lord. I'll serve them.
They need some time for inspection.
But the private parties, my lord, the school authorities. I will effect dusty service of your lordships. Can you
No, but then if you make it returnable, the whole application has to be made returnable. They have to be given at least a week's time for inspection.
My lord.
If something happens, you apply.
My lord.
You take out a one-page application giving notice to the school, then we will entertain.
My lord.
If you want an order of injunction.
My lord.
This public interest litigation is by an artist who is a resident of Maupon, Maupun, Golf Links, Shillong. He is concerned about a school building he is concerned about a building from which St. Anthony's Lower Primary School, comma, situated in Don Bosco Square, is run. Paragraph. Next, it is averred in the petition that this building is Assam type colonial structure and of significant architectural and historical value. It is also submitted that the management of the school is proposing to cause demolition of this building. He wants this demolition to be stopped and the building conserved. Paragraph. Mr. Khan Learned, Additional Advocate General, represents the government of Meghalaya as well as the Meghalaya Heritage Authority. Under the Meghalaya Heritage Act 2012. Although the school is a party, comma, it has not been noticed. Both learned counsel for the petitioner and Mr. Khan have taken us through the relevant provisions of the said Act. Full stop. Most importantly, Section 3 within bracket 2, where the authority on formation, where the authority constituted under the said Act on the formation of an opinion by notification in the official gazette invites views from the public whether a particular building or site is to be declared as a heritage, and upon consideration of the objections and suggestions received, proceed to decide the matter. The constituents of the authority are most senior government officials as mentioned in Rule 6. Rule 8 empowers the authority to empower any officer, to appoint any officer to assist the authority. Paragraph. Considering the submissions made, we direct as follows. Let a copy of this petition along with an appropriate notice be served by the advocate on record for the petitioner upon the respondent school authorities, namely respondent numbers 4 and 5, by dusty service and an affidavit of service affirmed and filed in court before the returnable date. Next, on the prima facie case made out in the petition, and in the submissions made by Mr. Khan, we direct the authority under Rule 6 to nominate any senior official to inspect the school building, make the necessary preliminary inquiry, full stop. On the basis of the said inquiry, now we'll strike it out. Mr. Khan is requested on the basis of the said inquiry to make submissions before us. With regard to the heritage status of the school building, to enable us to pass further orders in this writ petition. In one place you all said, learned counsel for the petitioner also submits that the school is actively proceeding to commence demolition work. In the absence of notice to the school, we are unable to entertain this allegation ex parte, full stop. But leave is given to the petitioner to apply before this court. If any urgent interim order is necessitated, upon due notice to the parties. We make this returnable after the vacation? After the vacation? We make this application returnable on 28th January. Rule is not section. Sections. Very clear.
Detail.
Item number 2.
What is this MC?
Please, Your Lordship.
Yes.
Lordship, the status of service of notice has already been filed.
Sorry?
The status for service of notice upon the respondent has already been filed. And when it was learned that the respondent is serving now at Chandigarh, so we took appropriate steps by service of notice through post. And I bet the...
Lordship, I have instructions to appear for the respondent.
All.
It's a sole
One
respondent.
sole respondent, Your Lordship.
Yes, you can proceed.
Lordship, at this stage, I'm praying for an opportunity for filing a counter affidavit, Lordship. This is a writ petition. I may be allowed to file my affidavit.
Lordship, there's an application for stay. So, if Your Lordship can come to page 51, Your Lordship, on my application. The respondent here, Lordship, has already been promoted.
Yes.
Page 51 of my application, Your Lordship. Lordship, may I read, Lordship?
Yes.
The Principal Director Staff Office of the Controller and Auditor General of India, New Delhi, is pleased to promote the following 51 junior translators to the post of senior translator in the pay matrix level 7 in the office mentioned in column number 4. Their promotion will be effective from the date of assuming charge as senior translator. Lordship, the name of the respondent appears at serial number 2. And this is since 2018, Your Lordship. Since 2018, he has already been promoted to that post, Lordship. So he has nothing to lose, Lordship, if the misapplication for stay is allowed, Your Lordship. I pray for that, Lordship. Because he's if you come to page number 193, Lordship, this is the impugn order. The relevant portion is at para 6, Your Lordship. May I read, Your Lordship? In view of the above, we direct the respondent number 1, that is the Union of India represented by this Controller and Auditor General of India, to revise the seniority list of junior Hindi translator and senior Hindi translator published by letter dated 06/02/2018 and 14/03/2018 as per the observation made above, and to place the applicant in appropriate place in the grade of junior Hindi translator as well as senior Hindi translator at par with his junior on the basis of the initial date of appointment. It has been further observed that as admittedly the private respondent number 3, that is Moshmi Das, was granted promotion with effect from 01/01/2014 in the grade of senior Hindi translator, where the applicant was granted the promotion after his representation on 28/5/2018. Therefore, we also direct the respondent to antedate the date of promotion of the applicant by fixing the date of his seniority notionally, at least with effect from 01/01/2014. So, Your Lordship, here, the respondent, as per the impugn order, it's directed us to notionally grant his seniority with effect from 01/01/2014. So, Lordship, here, since 2018, he's already been promoted to that post, Your Lordship. So, he has nothing to lose.
The notional effect has been given.
No, it's not been given as yet, Your Lordship. So, if he succeeds, then we'll consider that, Your Lordship.
Notional means only in future there will be increments.
Yes,
But from 2014 to
14.
18, he will not get anything.
That is what we are contending, Your Lordship.
That is notional.
I may be allowed to file my objections and the affidavit, Lordship.
So there is no
Before any-
scope of interim order.
Lordship, there's no interim order.
Yes, because if you win, you will get all the money.
Lordship, so at this stage, Your Lordship, interim order does not require any.
Notional is for fixation of pay in 2018.
Lordship,
But your back wages or pay have not been.
That's what, Lordship, he's asking from 2014, 01/01/2014.
Then that is actual, not notional.
I may be allowed to file my objection.
All right.
This is my first appearance today, Lordship.
Direction. ব্যাকডেট করে 2014 থেকে 18 যতটা ওদের স্কেল বাড়লো 18 থেকে ওটা অ্যাকচুয়াল পাবে Are you challenging that? The notional or the actual?
Notional,
You are
Lordship.
prepared to give.
Lordship, we are not prepared to give you. My contention is that
Notional with actual benefits from 2018. Are you
from
prepared?
2018 we will give you, Lordship. Why not? 2018 he is entitled to, Your Lordship.
Actual calculated on the basis of notional promotion.
Your Lordship, what has happened here? I don't know. Appointment letter. Lordship, come to page
No, no,
36, Your Lordship.
please understand what we are trying to say.
Yes, Your Lordship.
Suppose in 2018, his salary was rupees 100. Suppose he was given notional promotion from 2014. Say at that point of time, his salary was 70.
Yes, Your Lordship.
It increased 15 rupees every year. So 15, 16, 17, 18, So 75 plus 60, 80 by virtue of notional promotion, it would be say 120 or 30. That is the catch.
Yes, that is the catch, Your Lordship.
So you are prepared to give him actual from 2018.
No, Your Lordship.
So that is why. Yes, please take down.
Lordship, what I want to emphasize here is, Lordship, after the selection of the respondent under the Staff Selection Commission 2010, he was posted at AG office Shillong, and the respondent number 3 at the original application filed under CAT. She was posted at Assam, which is a local cadre. Assam is a local cadre and Meghalaya is a local cadre. So what has happened in this case is, the respondent in the CAT original application, he had challenged that how did the respondent number 3 got her promotion?
We have understood.
Yes.
So the two effects of notional, one is on pay,
Yes, Your
and
Lordship.
the other is on promotion.
Your
Between
Lordship.
2014 and 18, he might be claiming one more promotion also, which would in turn enhance the pay. So we have to go into that.
Yes, Lordship. So we'll hear them, Your Lordship.
Yes.
Let them file their application.
This writ petition is admitted. Let affidavits be exchanged according to the following directions. All the papers are not here.
All the papers are there, Lordship.
You want to file an affidavit?
Yes, Your Lordship.
By when? You can file it by 17th
Lordship,
or
we
after
can-
the vacation.
After the vacations, Lord.
All right. Affidavit in opposition by 2/8 January. Affidavit in reply by
Sole respondent.
10th February. List this application on 12th February.
Lordship.
Highly obliged, Lord.
Item number 3.
Yes, please.
Please, Your Lordships. Your Lordships, as per order dated 22/10/2014, 2 directions had fallen from this, from Your Lordship. Your Lordship, one being the state appellant is to deposit a sum of rupees 20 lakh with the Registrar General of this High Court, Your Lordship. That has been complied with. Your Lordship, we were also directed to prepare a paper book, Your Lordship, which has also been complied, and the paper book has been given to the respondents, Your Lordship.
Proceed, the appeal.
Your Lordship, I pray that this matter may come up after the vacations, Your Lordship.
By consent of learned counsel for the parties, list this appeal for hearing on February 10th.
Right. Your Lordship, I just want to point out one thing, that the unconditional stay that was granted by this court was only till 14th November, Your Lordship. The
Alright.
stay of the decree. Your Lordship, if I pray that the same may be extended.
The subsisting interim order will continue till disposal of the appeal or until further order, whichever is earlier.
Obliged, Your Lordships.
Item number 4.
May it please your lordship, it's a petition under section 37, my lord, of Arbitration and Conciliation Act challenging the decision of commercial court under section 34 and intern award, my lord. Facts lie in very narrow compass, my lord.
Mr. Advocate General, who is appearing for the respondent,
I am, my lord, appearing for the respondent.
is ready for hearing.
I'm too ready for hearing, my lord.
But they have filed the paper book, but the evidence of witnesses are not available in this paper book.
So we can, if we require, because
Witness before the learned arbitrator.
Yes, my lord.
You require that.
Because they, otherwise it is not required, but
not
if
required,
they
my
have
lord,
filed the
because,
paper book, my lord, then it should continue.
because evidence, whatever evidence is, the arbitrator is the judge of the evidence. We cannot, we are not even impeaching the assessment of evidence by the arbitrator, my lord. On those findings have been returned against me. I am,
The award is in their favor.
award is in their favor, my lord.
What is the amount?
Amount is about 99 lakh rupees, the total. 1 crore. 1 crore. We have deposited the amount in terms of interim order of your lordship, my lord. We have
1 crore.
1 crore 35 lakh amount, awarded amount.
1 crore. Total
1
amount.
crore 35 lakh.
1 crore 35 lakh, my lord.
So your application to set aside the award has been dismissed.
Yes, my lord. If your lordship will see one page, probably my friend can take instruction on that matter also, because matter can get resolved, my lord. If your lordship will see page 158 of the 158, my lord. Lordship will see claim number 2, that is 33 lakh. Claim number 1, my lord, I am not, page 158, my lord. Of the paper book. I'm sorry, my lord, paper book. Please give the paper. Volume 1. Paper book. Paper book. Lordship, kindly see the award of the learned arbitrator. Claim number 2, my lord. 33,50,845, my lord. This claim is with qua retention of 5% of the amount, my lord. Our case is that we have retained only 22 lakh rupees, not 33 lakh rupees. And arbitrator has awarded the precise amount retained by us is 22 lakh 60,174, my lord. And we have said so in our statement of defense, a statement of claim, but learned arbitrator has not at all gone into the issue, my lord.
Who's the learned arbitrator?
A learned arbitrator was
Honorable Justice D. Biswas.
Justice D. Biswas, my lord. So he was required to examine this aspect, my lord, that whether the claimant, when in SOD, my lord, a statement of defense, we have clearly said that we have retained only 22,60,174. The 33,50,845 could not have been awarded. At best, he was entitled to this 22,60,174, my lord. That is one, my lord. Similar is claim number 4, my lord. 57,39,000 rupees. There also, my lord, the learned arbitrator has wrongly noticed the figure and did not go through my figure, which was correct figure, because we have not retained 47 lakh rupees. We have. And the third fundamental error which has taken place, my lord, in the award is, my lord, kindly see claim number 10, my lord. 33,71,695, my lord. And this amount, my lord, we have not, this amount is awarded in view of the bank guarantee, which was never in cash, my lord. And it was not his case also that bank guarantee has been in cash, my lord. So the only bank guarantee, and he sought for release of bank guarantee document only, my lord, that the learned arbitrator has noted at page 155, my lord. Page 155. That is claim number 10. Claimant is entitled to release of bank guarantee of 33,71,000.
No, this claim number 4, retention amount.
Retention amount, my lord, we have
How much was actually retained?
At 22,60,174. That your lordship will find the figure is also there.
Claim number 2 also 22 lakhs.
Claim number
I'm talking about claim number 4.
4 we have retained, my lord. This is yes, 31. We have retained 31 lakh rupees, my lord. Claim number 4, my lord. Precise figure is, my lord. 388 is the precise figure which we have mentioned in our statement of defense. $33,50,845, my lord. And claim number 10, we have not retained anything, my lord. It's only return of bank guarantee which my friend has sought, and the learned arbitrator has awarded the amount. So on these three claims, if my friend can take instruction, the matter can be resolved with. Otherwise,
You have to enter a kind of a terms of settlement in court.
if my friend has to take instruction from his client, my lord.
So even if it takes,
Yes, my
then
lord.
a terms of settlement have to be filed. Otherwise,
Yes, my lord. It can't be decree of the court, my lord. It has to be.
I have still not been able to understand whether we can remand the matter to the arbitrator or not.
That
The court has the
issue
power.
that issue is grey area. Once award is set aside, my lord.
There are some decisions of the Supreme Court says that you have to file a civil suit
Yes, my lord.
or go for re-arbitration.
Re-arbitration, my lord. If the arbitration clause is there, then matter has to go for re-arbitration. Because if the
In some cases, and in other cases, it becomes res judicata.
yes, my lord, res judicata is also a grey area, because so far as claim number 2, 4 and 10 are concerned, my lord, 10 are concerned, these three claims are clearly no consideration, no discussion by the learned arbitrator, my lord. Claim has been reproduced by the learned arbitrator without examining my defense.
Say if the arbitrator holds that this award is without appreciation of evidence, but X amount, it is set aside.
Yes, my lord.
Then we have to look into the substance of the award to say that whether in a civil suit or a re-arbitration, it is the direction that you get it properly adjudicated.
Yes, my lord.
But suppose if it is simplicity rejection, claim for ₹100 rejected.
Yes,
I don't think you can file another proceeding.
Yes, my lord. If the claim is that, then it will be certainly hit by principle of res judicata, my lord. That will be
And
the.
whether court can remand matters that
Because I have seen, my lord, that even the court is leaving the parties to the remedies in accordance with law, my lord.
yes. That again make an application under section 11 and go to arbitration.
Yes, my lord. Because these three claims, my lord, this 33,50,845, if your lordship will see one more page out, my lord, at page 155, my lord, is the claim reproduced and awarded. Issues have been framed and issues have no relationship with the quantification. Entitlement has been decided, quantification has not been adjudicated. How much the claimant is entitled to, that has not been at all adjudicated by arbitral tribunal, and that is hit by Section 34, my lord, and even dample judgment of the Honorable Supreme Court, my lord, the recent judgment of the Supreme Court in that matter. Because wrong framing of issues has no bearing with the, because if your lordship will see, the issues have been framed with regard to entitlement, whether there was a delay or not. And some evidence has been seen by the arbitrator, my lord. I cannot question those, because so far as quality is concerned, the arbitrator is the final authority.
You are willing to give back this amount, return this amount?
You like to,
Retention of 22 lakhs,
because
33 lakhs?
no, there is one more aspect, my lord, with regard to limitation, because in respect of each claim, separate limitation is also there, my lord. So I would like to press that also, my lord. So if my friend wants the argument, I am ready.
No, if he agrees that yes, the retention money was indeed 22 lakhs, so you will give back the money.
Because, my lord, in my hands are tied in the case, in the sense that some evidence has been gone by the arbitrator, my lord. And then in 34, 37, your lordship is aware that jurisdiction is very limited. But I have a case in fact and law both, my lord, on all those issues, my lord. I have gone through the issues minutely, and where if I can say, my lord, that there was a latent defect in the working of by the contractor. Now, the latent defect, I filed a counter claim, my lord.
So your instruction is that say in claim number 2.
Claim number 2, 4, apparent error, my lord, 2, 4 and 10, apparent error.
No, the retention is 22 lakhs, but still they will not get that money back.
Yes, my case is that also, my lord.
And in 4 it is retention 33,
33.
but still they will not get the money back.
Yes, my lord. And 10 I have not retained any money from him. It's a return of bank guarantee document, and the arbitrator has given the amount. Even their claim in a statement of claim is only return of bank guarantee, my lord.
But you want to encash it.
No, I don't, because that bank guarantee has already elapsed. It's over, my lord. I have not encashed also. His case is also not that I have encashed. He was asking for return of bank guarantee.
Bank guarantee has expired, but the bank is withholding this amount. They are not releasing this amount.
The amount is with him only, my lord. It is his,
with the bank, not with us.
your money with the bank. Your money with the bank. It's not with us.
It is at your instance.
But bank is not releasing, withholding this amount, my lord, because of the pendency of
How
this.
can they? 2 independent contracts, one with you with the bank,
Yes,
that issue the bank guarantee. They have issued the bank guarantee.
they don't want to understand, my lord.
And one bank with them, they have returned the bank guarantee, gone. It is for between you and the bank to cancel the bank guarantee and to and to credit the margin money into your account, which they are retaining for providing the bank guarantee. So what do you want to do?
My lord, so far claim number 2 is concerned, their own document is saying that this is the LD deducted by them. There is no claim of LD. There was no counter claim, my lord. And the learned arbitrator has arrived at the finding that their delay is caused because of the respondent. How they can impose LD, my lord?
No, but you have to take instructions whether the money retained is 22 lakhs or not.
Yes, my lord.
33 lakhs, my lord.
33 lakhs or not in 4. And bank guarantee, yes, you have instructions.
Bank guarantee, I will take
On
instruction.
that basis, you proceed.
I will take further instruction about bank guarantee.
Yeah, then you file a supplementary paper book incorporating those papers which you think are not unnecessary but not there in the paper book.
Yes.
ठीक है ना, वेरी अच्छा। Leave is granted to the respondent to file a supplementary paper book incorporating a part of the depositions before the learned arbitrator not included in the paper book filed post hoc. Such supplementary paper book should be filed by 3rd February. (2025). And you take instructions regarding those matters.
I will take instruction.
List this appeal for hearing on 12th February.
Your Lordship, if it is recorded that my friend can come back with instruction on next date of hearing in the order, then possibly I will have to take instruction from my client also, my lord, because it's PSU, public sector undertaking, my lord.
All right.
My lord, date may be fixed in the first week of February.
12th.
I have some problem.
Second week you have problem.
Yes, my lord.
All right. Learned Advocate General. submits that the award in respect of claims 2 and 4
10.
are patently erroneous for the reason that they relate to refund of retention money. And that the actual amounts retained by the appellant are how much for claim number 2?
22,60,174, my lord.
22,60,174 in respect of award for claim number 2, and how much for 4?
4 is, my lord, 31,17,364, my lord.
33,17,364. In the award for claim number 4. Then paragraph. The award, that bank guarantees which clear
Claim number 10, my lord.
the award in respect of claim number 10, representing the value of the bank guarantee, is also patently erroneous inasmuch as the admitted position is that the bank guarantee was never encashed by the appellant and duly returned to the respondent.
Expired, my lord. Bank guarantee expired, my lord.
Full stop. It has also expired. The learned counsel for the respondent is to take instructions on the above points so as to shorten hearing of this appeal.
Grateful, my lord.
Item number 5.
May please, Lordship.
Yes.
Lordship, I pray this matter may be listed for hearing of verification.
It's ready for hearing.
No, Lordship, may this matter be listed for hearing after verification, my lord, since the conducting counsel is indisposed.
No, what is the stage of the matter?
It's ready for hearing. It's for hearing. It is in the hearing column itself.
So by consent, after the by consent of learned counsel for the parties, list this appeal for hearing on 12th February.
Much obliged.
From the dig list, item number 1.
Five criminal matters have been listed before Lordship, my lord. My lord, all these matters pertain to arise from one criminal proceedings going on before the session judge in Shillong, my lord. Here, what happened, my lord, pursuant to the directions of this honorable court, in a writ petition, my lord, CBI inquiry was directed against alleged irregularities in appointment of teachers in the state of Meghalaya, my lord.
Irregularities in?
Appointment of teachers,
Teachers.
school teachers, my lord. So CBI inquiry was conducted, and CBI inquiry found the then education minister, my lord, and some officers from the education department suspect, my lord, they accordingly filed charge sheet. Now, item number 2 and 3 are by the
A1,
A1,
the minister, my lords.
By the accused.
Accused
by the
minister,
for
accused
question
number
of the
one.
charges, my lord. For question of the charges.
The two aspects, my lords, insofar as item number 3 is, item number 2 is concerned, my lords. Item number 2, there is an order of segregation of trial between A1, A2 and A3. So A3, my lords, trial has been segregated. That order is under challenge in item number 3 and item number 5, my lords. Item number 5 is by accused number 2. And insofar as, my lords, item number 2 and item
They
number
are still ministers. Still ministers.
One of them, my lord.
One of them, my lords, petitioner in item number 2 and 3 is a minister, my lords, in the present cabinet.
And 4 former minister.
No, 4 is, my lords, he was the director of the education department at that given point of time.
Still is, no.
No, my lords, since
He's
democratic
superintendent.
office. 4, my lords, item number 5 is concerning, my lords, discharge application had been filed before the learned trial court. That has been rejected. So item number 2 and item number 5 are the challenges against that order, my lords.
In fact, my lord, in item number 2 and 3, Senior Counsel Salman Khurshid AP had argued the matter at length, my lord, from Delhi earlier.
2 and 3.
2 and 3, my lords.
These are 482 applications.
482. All of them are under 482.
And CBI's application?
Well, our application is against postponement of cross-examination of some of the witnesses.
That's a very minor matter,
That's a
my lord.
minor issue, my lord.
The main matters will be 2 or
What
3,
is the
4.
stage of the trial?
Still in the stage of examination of witnesses, my lords, evidence.
There is no stay order by this honorable court, my lord. The examination
Trial is
trial is
proceeding.
going on.
But what is the ground in the 482?
Well, it's insofar as, my lords, the rejection of the discharge application is concerned, we are saying, my lords, that prima facie, my lords, what has been submitted in the charge sheet, that does not constitute an offence insofar as the act is concerned, under the PC Act. That is the case that has been espoused because the evidence does not support, my lords, any kind of claim of the CBI.
What is to be done today?
Well, lords, these matters have come before my lord because, my lords, all the other courts have some difficulty, my lords, and they've recused. As such, it has been placed before Honorable the Chief Justice, my lords.
Prosecution evidence is complete.
No, my lords.
No, my lord.
It's at the initial stage, my lords. I'm told that the almost,
What are the grounds for your in 482?
well, as I submitted, well,
No, you said that the charge sheet does not disclose an offence.
well, the evidence collected in support of the charge, my lords, does not establish an offence, my lords. That is what was argued by us in the 227 application before the learned trial court. Now, that did not find favour with the trial court, my lords. Against that, we are before your lordships.
Which is an appeal.
No, my lords, it's under 482, my lords. It's come under 482.
To show us the order of the special judge.
My lords.
Was any arrest made? No.
No, in this case, no arrests. My lords would find that at page 61, my lords, of criminal petition number 71 of 2023. That is by A2, my lords, whom I represent. Item number 5. At page 61, if my lords have it. This is the judgment and order dated 23/8/2022. My lords have it. If my lords permit, my lords, I can read it.
No, I'm reading.
My lords. Those compilations are the reports.
Where is the order regarding A1?
Well, it's a common order, millets. The operative portions, millets, would find at
Page 82.
page 81 and 82, millets.
T1 and H2.
Paragraph 15.221 and 15.22, millets, are the relevant paragraphs. My lords, have paragraph 15.21.
Affidavits have been filed.
Affidavits, no, my lords.
Direction was given.
We were permitted to file compilations, my lords. I think certain parts of the compilation have been filed.
But in fact, the main matter, item number 2 was argued at length, my lord, before the other court.
If my lords permit, what there was a request made by us, my lords, to file a compilation because the charge sheet itself runs into a few thousand pages. So the relevant extracts, my lord, we had requested, my lords, and sought permission of this court to file it. That was granted to us by the order dated 19/6/2024. As well as written arguments also.
So it can be heard out on these papers itself.
Well, I would pray, subject to what my lords feel, if your lordships permit us, that compilation which we had prepared, my lords, we'll circulate it in advance.
What does the compilation?
My lords, the excerpts from the charge sheet, which would be relevant for the purposes of my lords adjudicating of these matters for your lordships.
That is interpolating and altering the mark sheet. That is
My
the
lords,
principle.
my lords.
So that the favored candidate is preferred over the others. That is the
That's the sum and substance of the matter.
and allegedly the minister took the mark sheets and made the interpolation herself in her,
Made corrections on her own.
while it was in her custody and using
Whiting.
to. How many witnesses you have, Mr. Mozarika?
My lords, I am instructed it's almost to the tune of over 500 witnesses, my lords. Out of that, not more than 16 or 20, 16, roughly between 16 to 20 have been examined as so far. My lords, we could have those papers compiled jointly, file it with the registry of this court, and may I pray, my lords, can then have it sometime in February, where we can address our oral arguments before, my lords.
Madam, the charge sheet has been annexed in one of the petitions, my lord.
This is which one?
Criminal petition 36.
Only
So the body of charge sheet is annexed, my lord. Maybe the supporting documents, the entire, all the
the
documents are-
supporting documents are, my lords, on the basis of which my lords would then read the charge.
You did 162 witnesses.
But the charge sheet has not mentioned.
500.
Because what happened, my lord, the teachers themselves who were illegally appointed, they themselves are witnesses, my lord. But on that aspect, my lord, minimum how many witnesses CBI requires to examine? I'll have instructions for next statement. The grounds taken in the criminal petition under 482, my lord, this honorable court will not examine the matter on merit.
It has, my lords, any material which is of sterling quality, my lords, cannot be ignored.
Anything concerning the trial, the court can go into.
My lords.
My lord, they filed a petition
Now,
to
this
discharge under
162 witnesses lead to an oppressive trial, then the court can interfere. You tell us. I don't have much experience in criminal matters.
because what we have
Law is
submitted,
well settled on this, my lords, insofar as how an application under 227 is to be dealt with.
what we have submitted, my lord, there are clear pointers towards the involvement of A1, A2, and A3. my lord. There is sufficient material to against them to frame the charges, and that's how even the London trial court has dealt with all these issues, my lord, and directed for framing of the charges.
That any prosecuting agency would say, my lords. It is only for your lordships to then examine that the investigation that they have conducted, my lords, whether it supports any criminal offence in the first place. If a case of criminal offence legally is not made out, my lords, then I would be entitled to this.
Offense is made out, but the court cannot go into the merits of it.
No, my lords, we will not go into the merits, my lords. We are on that limited issue.
But then the court can pass orders to make the trial fair and impartial.
My lords.
So next day you bring a shortened list of witnesses to this court.
We'll do that part, my lord. In item number 2 and 3, the council.
Mr. Khurshid will be appearing, my lords. That's what I'm instructed. Mr. Khurshid will be appearing for A1. I am here representing A2, my lords, for item 4 and 5. What we'll do is, my lords, the relevant extracts, whatever we are relying on, we'll try and make a short compilation, serve it on my friend in advance, my lords, and file it with the registry of the court.
These applications are all connected with criminal petition number 12.
My lords,
One petition.
just a second. 12 is the, my lords, matter. This will be the miscellaneous matter, my lords. I don't think this will be the lead matter.
No, the lead matter will
can be
be
36.
criminal petition number 36 or 23.
Item number 2 can be taken as the lead matter.
All right. The lead application in this case is criminal petition 36/2023. The others, criminal petition 12 of 2023, 37 of 2023, 70/2023 and 71/2023. Are connected with this main application. Fair enough. They are heard together and adjourned till you give us a date.
Would the 20th or the 21st of February be convenient?
20th February 2025 for further hearing. There are 3 accused in this criminal case. They are accused Where is the order of the special case? Page?
My lords, page 61. The A1, A2, A3's description, my lords would find at page 61.
What have I said, does? Of legally subverting the process of selection and appointment of assistant teachers in lower primary school, Government of Meghalaya in the year 2008-2009. Post up. CBI was, the Central Board of Investigation was entrusted with the investigation by the High Court. Paragraph so far. Investigation of the case, bracket PS case number 62, bracket 07, 2011. Under sections 120, capital B, 167, 466, 408, 34, and 34 IPC. Paragraph so far. Only 16 witnesses for the prosecution have been examined.
Well, it's 16 to 20. Let's already.
Or not more than 20 witnesses.
Not more than 20.
Prosecution have been examined, full stop. It is learned that the prosecution has about 162 witnesses. Paragraph. These petitions are for inter alia, washing of the proceedings, criminal proceedings before the learned trial judge. Now, what are these petitions by the accused? On various grounds, full stop. The ground made out by the first accused who is also an honorable minister in this state, is that the charge sheet does not disclose any offence. Paragraph. These applications have to be heard out. Then you put that earlier one you transfer here, that list these applications for further hearing on 20th February. Paragraph. Prima facie, I am of the view that this criminal proceeding from the police case stage is pending for over 13 years. Full stop. It is high time it is disposed of. Paragraph. If the application to quash the proceeding succeeds, then that would be the end of the matter. Paragraph. If it does not, examination of 162 witnesses would, in my opinion, make the proceedings extremely dilatory, long, and unfair to the accused. Post-up selection of witnesses should be so made so that the required number to prove the case beyond reasonable doubt is produced. Full stop. Unnecessary witnesses and evidence should be avoided. In those circumstances, learned Deputy Solicitor General is requested to impress upon his client CBI to cut short the list of witnesses in the light of the observation above. Paragraph. Since such a slow progress in the conduct of the case has been made over the past 13 years, it would cause no prejudice if further trial is stayed till conclusion of hearing of these applications. Full stop. I am not minded to grant an indefinite stay. Full stop. Stay of the criminal proceedings till
My lordship, staying, my lord, only one small submission, my lord. This honorable court directed for CBI inquiry in 2017, my lord. Though the recruitment of 2008-9
There's a spate of litigation before.
and charge sheet was filed in 2020, my lord.
it's all right, but it's pending from 2013. It may have been pending before the ordinary court. Then the CBI took it over.
Lord, CBI took it over in 2017, my lord.
Yes. But the case has to be taken from 2013.
That's when
where
the
it was
first
being-
FIR was
Madam,
where
ma'am,
it was being handled.
But in my humble submission, since right from the inception, there is no stay order, my lord. My lord, otherwise also criminal courts there will be vacations and other things, my lord.
Only 16 have been examined.
My lord, I do not have exact instructions.
Well, it's,
But this is what
20, less than 20 millions. There's a statement made before in the bar, so obviously it would.
But in my humble submission, my lord, let there be no interim order at this stage, my lord. I'll come back with all the instructions on 20th February. On that day, after considering submissions, my lord, lordship made.
When is it? Well,
I said, you replace that with business.
Lordship may consider that on next date, my lord.
Till the list is finalized by the Central Bureau of Investigation, it shall make appropriate submissions before the learned criminal court with regard to further examination of witnesses.
Right.
Because I was minded to stay the proceedings only till 31st March, that's all. By then it would be over.
My lord,
But anyway, it's all right with this.
so there's some political ramifications also this case, my lord.
All right. list on 20th.
The
Right.